Okay, good afternoon, everyone. I'm Carlton Mace, Vice President of Sales for Quadro Counsel, and thank you again for joining us for the 12th presentation in the QC webinar series. Today's webinar was originally posted as Dividing Calpers Retirement Benefits, but in addition to that, we have a little bonus of also discussing CalSTRs plans as well. CalPERS is the largest of the public retirement plans in California, and special consideration for the CalPERS members and the ex-spouse need to be taken into account when dividing those type of plans. Topics to be covered are the differences in dividing the plans for active and versus retired members, how value estimates may be helpful, how to handle disability, and addressing the pitfalls within both the CalPERS and the CalSTRs plans. Our expert speakers today that you see are John Madden and Louise Nixon. John is a nationally known retirement benefit valuation expert in dividing marital and community property and divorce cases. Since 1999, John has been a recurrent expert witness for the courts on the subject evaluations and quadros. He is also a frequent speaker on the subject, including for AAML, ADFP, and numerous bar associations. In addition to Quadro Counsel, John is a co-owner of the consulting firm Moon, Schwartz, and Madden, and is a member of the Quadrones, a national study group comprised of Quadro attorney and pension valuation experts. Louise is a nationally recognized Quadro expert also, and since 1994, she has practiced law specializing in retirement benefit division and quadros. Louise is a recurrent family law court appointed expert on quadros and a speaker on the subject. She has been quoted for her expertise in the Bloomberg Report, the New York Times, and the Wall Street Journal. She was awarded the Pro Bono Attorney of the Year by the Harriet Buhai Center for Family Law, a nonprofit which provides free legal services for low-income families in turmoil. And she currently serves on its board. Louise continues to practice law with Quadro Benefits Law Group and is also a member of the Quadrones. Please know your microphones are turned off, and if anyone has any questions during the presentation, use the Q&A function to post your question, not the chat room. We will address all questions. And John and Louise, you may start the presentation.
Hello out there. I wish I could see your faces and do this in person, but I'm glad that we're able to connect today. And hopefully John and I will be able to answer some of your burning questions regarding PERS and STRs. Just a brief bit on Quadro Counsel, if you're not familiar with it. I know we have some subscribers that have logged in and people that are already familiar with it, but John and I, along with a team of experts and technical experts, technology experts as well, have created this platform. It's an online legal services platform to help the divorce professional deal with retirement benefits from the beginning of their case when they get it through the judgment, and also doing the quadros if they wish. So it's a very comprehensive platform. We have now about 20 people involved with it. It's very exciting to see the growth that has taken place over the last couple of years. And we're happy that we're able to share our knowledge with you. All right, so these are some of the other experts, the goals. So John and I are gonna break this down and comment back and forth, but I'll start with the first part just on the basics, because a lot of people don't realize this, that there are, for public plans as with private plans, two types. There's defined benefit plans, which is in most cases a monthly payment over the lifetime of the member or the non-member in a divorce, and defined contribution plans, which for public plans are typically 403B plans or 457 plans. They both still require quadro, but all these plans will technically the 457 plans are governed by ERISA, but generally these plans are not governed by ERISA, certainly not the defined benefit plans. So we refer to them as technically as DROs, as domestic relations orders. So DRO can be your judgment because it's a domestic relation order ordering a division of an asset. It may not be able to, in most cases, you've got to do a separate domestic relations order just for that particular plan to do the division. The division for all these plans relates to division of the community or marital property, but you can also do DROs for support. So one thing that a question we get a lot is creating the hold. How do I create a hold on the account, especially if you're nervous and you're representing the out spouse and you don't want the participant to retire. So a few throw-ins here for military or federal employees, you cannot create a hold until you serve the actual filed DRO, domestic relations order, on the plans. But for state plans, for most, in California, in almost all cases, if you do the joinder platings or even prepare a notice of adverse interest, a hold will be created on the plan. There are a few nuances with that, with a plan if the member's already retired, but for the most part, that applies. Certainly for all California public plans, you have to do the joinder platings in order to proceed with filing a domestic relations order. So I believe you'll have access to this PowerPoint, but we just go through the different forms, the judicial council forms to do the joinders. What's great about our platform with Quadro Council is we have automated with all the boxes checked and very specific instructions for you and your staff, so that it literally takes 5 or 10 minutes to do the joinder platings for the different plans. The notice of adverse interest we've also automated on the website, and for public plans, just will wipe out federal and military. You can't do anything with them. But for a notice, you just provide a notice to the public plan. And for California public plans, you may want to do a notice of adverse interest if you want to make sure the plan, if you don't have time to wait for the joinder platings to get back from court, from the clerk to sign it, to serve it on the plan because the participant is about to retire, or you think the member is about to retire and you want to make sure that there's a hold on the account. So it doesn't hurt to do both. You have to do the joinder platings, but if you're in a hurry and you want to make sure nobody retires or does any nefarious action, then during the pendency of until the quadro is done, then you want to do a notice of adverse interest. So, okay, sorry. Okay. So now we're gonna jump into California plans, into kind of a deep dive. And by the way, I can't see when I'm doing this. I'm the one controlling the PowerPoint. I can't see the questions. So if there are any questions, we'd like to answer them as they come in. John, can you see them, the questions on your end? Okay, so you let me know, or Carl, let me know.
Oh, yes.
So we can answer them. So I'm going to hand this over to John and then go from there.
Okay. Hello, everybody.
Yeah.
So California public plans, that covers state, county, city employees. And they have, as Louise said, both a defined benefit plan and a defined contribution plan, or plans, which would be similar to like your 401k plan. For the pension plans, depending on which plan in particular we're talking about, we would be using the typical time rule approach, or if they have what is called the segregation method, which most of them do. But as we'll talk about with Calpers and CalSTRs, they have both the pre-retirement time rule and a pre-retirement segregation method. And we'll talk about sort of the differences with those. And then most of the municipal employees are considered state employees and would have a CalPERS. There are a few municipal plans that have their own retirement, but most of them far and away are CalPERS employees, or covered by CalPERS, I should say. And then for CalSTRs, again, similar to CalPERS in that there's two pre-retirement types of division methods. The county employees have their own county plans, and even within the county plans, they have variations. So not all the county plans act in a similar manner when it comes to dividing them. Plans that offer different options, from unmodified, which is, for the member's lifetime only without any type of survivor benefit. And then a lot of the plans also offer optional survivor benefits up to 100% to the designated beneficiary surviving spouse. And then, of course, unless the separate interest order, if the plan allows for a separate interest, then that would be one way of doing it. But if they do not, or it's decided that the shared interest is still the better option, then the DRO must also address a survivor benefit for the non-member spouse. And then with the public plans, as I said, we've got CalSTRs, their website, their pre-retirement choices are similar to what CalPERS also offers. But I think, Louise, are we going to go into a little bit more with CalSTRs now?
Yeah. Yeah.
Okay. So with CalSTRs, so it's important to know, and this comes up a lot, Louise, I know it does for you, and that is who gets to decide if you're going to do a shared interest or a segregated account interest order. And with, so the answer to that is the non-member, and that's firmly confirmed with the non-member in Family Law Code 2610A3. They get to choose between the separate account or the shared account. Now with CalSTRs, what you have to take into consideration, obviously are the age and the health of the parties, length of marriage, employment, the salary at separation. So this is one of the key components to a separate account division under STRs. They freeze the non-member's salary or the member's salary for non-members calculation as of the date of separation, not the date of commencement. So of course, if they separated 10 years ago, they would be using salary from 10 years ago to calculate the non-member's benefit. And it's for those types of reasons why the Family Law Code says it's the non-member's decision, because they're the only ones that are really going to be negatively affected by it.
Okay, I'm moving forward. We're going. Tell me.
Yeah. So segregation method, pre-retirement only, benefit for the non-member calculated based on the member's compensation as of date of separation. The member has to have at least 5 years of service credit. Then the non-member, and if not, then the non-member will only receive a refund of the member contributions and interest, which if any of you have seen my talk on valuation issues that QC has done, that's just that refund of the member contributions and not the much, much larger subsidized monthly benefit. So again, a refund is never typically a good idea for either the member or the non-member. And then, of course, the member must be vested at the date of separation. Non-member may elect either the refund of contributions and earnings, or they may elect a monthly retirement when the non-member turns age 55. Again, so the refund, never really a good option. The monthly benefit is where the subsidy lies, and that's where you have the question of separate account DRO or shared account DRO.
We have a question.
Yeah.
Larry, I think it's pronounced Laborde.
Oh, hi, Larry.
Good. Can you do a DRO on a spousal support order only, no child support?
Yeah.
Yes.
So that's 2 yeses.
Yeah.
For the member has to be retired to get to do that for a public plan and for a private plan.
Right.
So
you might consider if they have like a 403B or something else, maybe you could do an order on that. But for the pension plan, if they're not collecting, then that would present the problem. But they can be done.
Okay.
We
Okay.
can help you, Larry.
Right.
Get the camera.
So shared interest. So this is where the non-member has to wait for the member to actually retire. But on the member's retirement date, non-member receives a monthly benefit based on the time rule. The shared method is used in a pre-retirement type of division, but a shared interest is also used in a post-retirement type of division. And again, I mean, it's, you know, two different methods, the shared version, but right now talking about pre-retirement and now post-retirement. So when you have a domestic relations order that is a shared interest and there is a survivor benefit either to be elected or in a post-retirement system, if there's a survivor benefit that has been elected already, STRs is unique in this in that they allow you to modify the survivor benefit election made at retirement. Now, most of the times, and for reasons we'll, you know, if you have a question about it, we can go into it later, but most of the time it is beneficial to the parties to just keep the option that they had elected at the time of retirement and then just work, you know, that out in the draw. Pre-retirement, we do have a compound option. Basically, that's the same thing as what Calpers has, which is called option 4. It basically allows you to customize the survivor benefit so that you can have the non-member receive their regular 1/2 community interest with a survivor benefit also equal to 1/2 of the community interest. And then, of course, the non-member will pay the cost for that survivor benefit from their share.
Because they benefit from it.
Right. They're the only ones benefiting from their survivor benefit. Again, because we are allowed in the DRO to customize the survivor benefit. So member is free to elect another survivor benefit for someone else, and then they would pay that cost because they're the ones benefiting from it.
Right.
Yeah.
So, yeah, I mean, this is that we're throwing a lot of information at you, and we're going to deep dive right now into the different fact patterns when you would choose the segregation versus the time rule or the shared interest. And for those of you that don't know, since I don't know who's in the audience, the time rule is the credits, because these are all done by pension credits that have accrued during, probably should do a slide on that in the future, that have accrued during the marriage over the total credits that have accrued through the date of the participant's retirement. So that's the formula. I think most people are probably familiar with it that are on this webinar, but we can certainly provide more information to you on time rule and the marital fraction, which is a method to divide defined benefit plans pretty much in every state. So that's what we use here in California. Okay, go ahead, John. Sorry.
Yeah. So with the segregation method, again, the non-member would have to be at least 55 before they can start drawing their monthly share. The member, if they're continuing to work, or perhaps they've left work and is not expected to return, therefore, sort of hanging on in case there's any higher salary later on wouldn't play into it. Or again, if it's a very short marriage and the non-member wanted to refund for their share of the small contributions, or in the event that the member dies pre-retirement before being eligible to retire, that's generally when the separate account, segregated account method is going to be used. A lot of times on the surface, I think people read the models and they say, well, the segregation method seems easier to understand, and they would choose that one. When in fact, again, if the date of separation was 10 years ago, you're going to be using the salary from 10 years ago. So it's just, it's certainly an appropriate method of division under the right circumstances. But that's the big warning, I think, with the segregation of account. It's just the fact that they freeze the salary on the date of separation.
So if the non-member is over 55 And I know sometimes there's an issue with maybe the support. They want to keep getting support if they're paying, but if they're not getting support and they want to start the pension right away, or because sometimes the support adjusts once they start the pension and they want to keep that going for as long as possible. I know those are the issues that come up with waiting, and the data separation wasn't too long ago. And the member's still working. It may be in the best interest to select a member, and Quadro Council is here to help you make those decisions. You can get estimates from CalSTRs. We can help you with that. We also can do the estimates. So there's a lot of ways with CalSTRs, unlike PERS, which you we'll get into in a minute, for you to get really concrete information so your clients can make informed decisions on which way they want to go.
Right, so shared interest method often selected under the following fact pattern, where the non-member wants to wait until the member retires to receive possible increase in post-separation salary increases. And again, if you have people that are in their 40s, well, you can't start collecting at that age anyway. So a shared interest would make sense. But again, if they're in their 50s, say, with a recent date of separation, perhaps if you don't believe the member is going to receive salary increases, then a shared interest may not be the way to go. As Louise said, if non-member is currently receiving support, or as non-member was younger than the age 55 and the member is still working or about to retire. So yes, there's definitely many factors to consider for each individual case. And I know we always say this, Louise, but just because the last case you had maybe used a shared account division does not mean that the next case you have, you're going to want to use a shared account division. So every case changes, so you just have to look at it with fresh eyes each time, really.
Well, that's for sure, because I recall, and this happened more than once, where I've been asked to review a quadro that was done by another expert, which not you, John, but somebody else, but other people. And or it was done by a family law attorney, because I thought, oh, I'll just keep doing the separate interests quadro, because that's the easiest one to do. And when the members, especially when they asked me to review it to see, what to do, because of course the non-member gets to decide. For the separate interest, sometimes it is definitely in the member's benefit, and it could also be in the non-member's benefit for sure to sign. But in some of these cases, I'm telling the client, sign this thing as quickly as possible. It definitely is in your favor for her to do or him to do the separate interest, because of the freeze of the value of the credits that did a separation and the ability to just segregate the account, move forward. So definitely you want to take time to consider these issues. So now we'll jump into CalPERS. We can do a deeper dive into PERS.
Yeah. So again, CalPERS, pre-retirement choices, shared interest, segregated account division. There are similar, issues with both. Again, non-member, pursuant to family law code, gets to decide. CalPERS, unlike CalSTRs, CalPERS will not provide a member, non-member payout option. They're not quite as flexible or as user-friendly, I guess, as CalSTRs. But some of the things to consider, age, health of the parties, length of marriage, employment, salary. Again, now the difference here between STRs and PERS is PERS separate account will freeze the salary on the date of dissolution. So again, you need to take that into consideration. And then of course, trying to figure out when the member is going to retire. And then we have, and the nice thing is too, which Louise, I know you were saying that Quadro Council can help with this decision, is we have a calculator, a tool that runs the Model A versus, the Model A segregated account income streams to member and non-member, and also the Model B shared income streams with the that survivor benefit cost. So that can be helpful when you're trying to figure out which one you want to use. The separate account method, pre-retirement only, generally benefit for non-member calculated based on the member's compensation at the time of judgment. member has to be vested. And then if the non-member elects under the segregated account, they can either, provided the member is vested, they can either receive a monthly benefit based on dissolution salary, or they can elect to receive the refund of member contributions and interest thereon. And then separation of account method, if member is vested at time of divorce, the non-member may elect either a refund of the contributions and earnings, or they can elect the monthly benefit, provided that both the member and non-member are at least age 50. So this is one of those differences between STRs and PERS. STRs, the non-member just has to be 55 to start collecting their separate account. Under CalPERS, both have to be at least age 50. So yes, so then the shared interest, again, time rule. Once the member actually retires, the non-member would receive their awarded interest based on the time rule. We have a shared method used for pre-retirement, what PERS calls their Model B, and then the shared interest for post-retirement, which is what PERS calls Model C. And so with the shared interest time rule, again, so for a pre-retirement type of Model B shared interest time rule, you will see language in there that talks about option 4. That's the same thing as CalSTRs, where they talk about the compound option. Option 4 simply allows you to say, 50% of the community interest to the non-member spouse with a survivor benefit equal to their awarded interest, and then the non-member spouse will pay that cost, and the member can elect another survivor benefit and they would pay that cost. Now, in a post-retirement situation, you have to have a qualifying event in order to change any kind of spouse beneficiary designation. A lot of times, it's not worth it. You can't really do that anyway, or it would be financially shooting themselves in the foot. So you end up just keeping it intact, similar to CalSTRs, even though you can change it in STRs. PERS, a lot of times you can't. But I think at the end of the day, Louise, most of these people just keep the survivor benefits, because they have to or because financially they should. And that's what we almost always advise after running the numbers for them. But the big problem under PERS is this 2W and 3W. And basically, if you have a member that has a 2W or a 3W, you're pretty much stuck with that election, and that you're not allowed to change it. That W basically means without modification. So that presents problems. And I see almost all the PERS members nowadays have elected the W versus the regular option 2 or option 3. So that just presents a little bit more of a challenge, but I know Louise and I have been through this a million times on various cases, so well equipped to help navigate through that.
So just real quick, because we forget, what we covered, what we have. The option 2 is, and I should have written in the PowerPoint, sorry about that. That's 100% option. That means if the member dies, that the spouse who the member had retired with, or in the case of a divorce, the former spouse would receive as the beneficiary 100% of the pension for the rest of their lives as the beneficiary. And the option 3 is where you can choose different percentages between 50% up to 100%. But the W means that there's no pop-up. So if the member dies, if the non-member dies, the amount of the monthly pension stays the same, even though there is no survivor benefit awarded. And what that means and why people choose the W or the 2W, 3W is because they get a larger amount paid to them while the member's alive. So if there's a pop-up in the event the non-member, we're diving too deep on this probably. If the non-member dies, then the amount of the monthly benefit while the member's alive is less. So just background information on this.
Right. I know, because the 2 and the 2W, they look almost identical. on paper when you're looking at the payouts, but the 2W, maybe it's, $30 less a month in cost, so that people say, oh, well, let's take the W and save the $30. But they don't realize that, upon divorce, there's a huge difference in, what you can do with the 2W versus the 2. So again, how do you choose, do the valuation, get income streams, because really that really helps, I think, people understand how, what possibly waiting and getting a benefit of salary increases versus doing the separate account, division now with date of dissolution salary. All of these things, can be boiled down into, monthly estimates to help decide. So separate account method, fact patterns, non-member and member both have to be age 50 or older. Member still working, but non-member wants to receive money as soon as possible. If member left work, not expected to return. Short marriage, non-member wants to refund, or member dies before eligible to retire, in which case that's the only option that's available is a refund. And again, if you've got clients that are under the age of 50 and you're worried about, possible death of the member, then you might want to look at maybe getting some life insurance to just kind of make sure that the pension value is going to still be there in the unlikely event that the member were to die before becoming eligible.
Also, Quadro Council, we developed this plan analysis tool in addition to the actual valuation that we can do for the to come up with what the monthly amount would be. And I think people have found that really helpful because it goes through so many different scenarios and gives best tip of what most people choose based on particular fact patterns. So these are just some of the tips that are in this PowerPoint, but depending on your fact pattern, with the plan analysis tool, you would go through, answer the questions based on the facts of the case, and you would get a report immediately that would give you a good idea of what most people would choose in that particular fact pattern. And that's without even doing the estimates. And then you could, of course, for sure, do the estimates, which is sometimes a good thing, but sometimes you don't have access to the information. There's not enough money in the case to subpoena or obtain that information from Calpers. And so, if you're representing the outspouse, sometimes that might be the best way to go, is just to look at the plan analysis tool. So.
Right. And then with the shared interest, if non-member wants to wait until the member actually retires, because they might, maybe they believe that the member is going to receive some, decent salary increases from now until the member's retirement. They certainly have the right to choose the time rule model B shared interest and just wait it out. Or as Louise said, if they're collecting support and they want to wait, then they can certainly do that. And then non-member, if they're under the age of 50, they have to wait at least until they're both age 50 anyway. So it might make sense for the non-member to go with the shared interest and see what happens. One thing also is that, if you decide that if you're working with non-member and you decide that the model B shared interest is the way that you would like to go, until the payments are actually triggered, you can always go back and amend it to a model A. So it's not just the, set it, forget it, you can't do anything. You can still change it with an amended order if, circumstances justify it. So as I said before, with all this stuff, just because you did something in the last case does not mean you want to do it again in the next case.
But you don't want to wait either until the member's about to retire to make these decisions. It's really to protect the rights of the outspouse, especially, but also just, so the parties can move on. You want to do at least, one of the two orders so that, it's done.
Right. And not to get too into this area, but the notice of adverse interest joinder stuff, I mean, to be able to do that as quickly as you can it's paramount, because being able to lock up the pension to prevent the member from electing, or maybe they're going to retire for disability, which of course, is their right to do so, but you want to make sure that you've given yourself enough time to address these issues to get the order in place prior, and that's very, very important. So yeah, so we'll talk about CalPERS and common mistakes.
This is that we always try and touch on this when we touch on CalPERS.
Right.
It's a big problem. So here we go.
Yeah, and this is where I've seen a lot of judgments being set aside, and it's just not good. So I mean, and it's because of this error that is rampant throughout California, even other states. I've done some valuation work in other states, and it's not just California. So here's members considering buying out the wife's interest in the pension. We'll say husband is the member. What do you have to do to get that done? So you have to calculate the monthly benefit under CalPERS. And we have a calculator that does that. Once you get the monthly benefit, now you have to figure out, okay, what does that mean in terms of actuarial present value? And the parties then will decide whether or not they want to, work out a deal with offsetting other assets. But if you don't end up with an agreement to offset, then you do have to go back to the deciding whether or not you want a Model A or a Model B type of order for division. And right, and then you just draft that order. So again, there's several steps to go through, but again, at the end of the day, you've calculated the monthly benefit, calculated the total value. So at least the parties know it's worth a lot more than what perhaps they believe it was. If they don't work out a deal, that's certainly fine. Then you just draft the order based on what method the non-member will pick. So this is that area that we see the mistakes, really malpractice that we're trying to get people to avoid. So this is your standard CalPERS annual member statement. The member has paid into the system. So CalPERS is a contributory defined benefit plan, meaning their members pay a portion of their salary into the pension. So this member has paid contributions and interest of $167,000 and has accrued 16.6 years of service credit to date, and has a current salary of about $9,100 a month. So at age 55, this member is going to get $4,500 a month for life, with generally 2% compounded cost of living adjustments. So that's a very, very valuable benefit. And this is one thing. So and even PERS will tell them the members and non-members this. So if you were working with non-member and they say, well, PERS told me I can get a lump sum payment of my interest. The lump sum payment is only a portion of that $167,000. It is not based on what is really the full actuarial value of 1.14 million. So simply put, even though there's a lot of math behind that calculation, if you just think, if the pension is only worth 167,000, that's the area that I see parties, financial planners, attorneys, they think it's worth 167,000. Well, that is where, if you think about it, 167,000 and you're drawing $4,500 a month, it's only going to take like less than 4 years to completely drain the account. But yet it's a monthly lifetime benefit. So, I mean, it's worth a lot more than the 167,000. And that's
so what we see is people settling and say, oh, wife has a 401k worth 200,000 and husband has a 401k worth 170,000, and so they offset that and just do a quadro for like 30,000 or something off some other asset. It's a problem. Yeah.
Right.
Yeah.
Right. And yeah, so I mean, I've seen a lot of cases where, everything blows up because they think it's all resolved and they come to get their quadro done. And it's like, well, there's a missed asset here of, close to $1 million. So what do we do?
And these are you think about it, John. I mean, we see what percentage, how many CalPERS members are getting divorced? Probably a lot. and we don't see all of them. We see a lot of them. Think of, I mean, there's a lot of horse trading that goes on in divorce, which is a great thing, but this is like a major horse trading accident. And it happens to, you know, I see it on every type of attorney when we get the judgments and we are able to fix it, we catch it, you know, let them know that you shouldn't be doing this. It doesn't matter how, I mean, the thing about retirement benefit division, there's so many little nuances, but that's the whole point of why John and I and a team of us have decided to, you know, create this platform to make the information accessible so that you have a resource to go to, so you can say, okay, I can find out this information so I can do right by my client. And that's what we're trying to achieve here.
Right. And, you know, a lot of people looking at, you know, the valuation side of it for the moment, you know, a lot of attorneys say, well, you know, we don't need the actuarial valuation because we're just going to do a domestic relations order and be done with it, you know, and certainly, you know, that's great. But if you're working with a non-member client and you really don't understand the value of these things, and they say, well, I'm going to get a lump sum of about $80,000. If you had done the actuarial, even if you didn't use it, you would know that your client's interest is worth about $500,000. So, I mean, you would be able to tell your client right away, wait a minute, something's not right. Why is your lump sum only 80,000 when we were thinking it was more worth about 500? So, I mean,
we have a couple of questions before we keep going, I think here. First one is from Catherine, I think it's pronounced Schlotterman. If there is a buyout, is a DRO still needed to confirm husband's 100% interest in the pension?
Yeah, good question.
Yeah.
That's the answer is no.
Well, I mean, assuming if husband is the member and they're buying out the non-member's interest, then you would want to have something in the judgment that says the husband's awarded all of his pension, right? Something along those lines.
So actually, that brings up an interesting. Thank you for that question, because what I have also seen in judgments is an award of, especially if the member, well, in some cases where the member's already retired, and they award 100% of the pension to the member, and the rest, you know, of some sort of offset to the former spouse. But if the member's already retired and elected an option, well, let me backtrack. In that case, so Calpers, that option would go away, right? So that's a good thing. That would be a reason to do it with Calpers. For STRs, you'd have to, well, with STRs, John, they would have to undo the option that was selected.
Yeah. So, I mean, again, you know, depending on the type of option, you know, if it's Calpers and they do a valuation and a complete buyout of the non-member's interest, then if it was pre-retirement, then you can just put in the judgment that the husband keeps 100% of his pension due to the offset, and you're fine. If it's if the husband's already collecting his PERS pension, then it depends on whether or not, you know, a survivor benefit was elected. And if one was, then it depends on whether it's the kind that you can actually get out of or not. CalSTRs does allow you to unwind the survivor benefit post-retirement. So they're a little bit more flexible. I know Jamie also has a question here. Does CalPERS provide the statement with the present value? So basically this large number that I'm saying it's worth, no, so they don't. So I guess thankfully for me that they don't, but no. So, I mean, you would have to get an independent valuation expert to come up with, you know, what is 16 years of service credit worth in today's dollars based on, you know, normal mortality projections, interest rates, salary, those types of things. But clearly, you know, I would say the CalPERS members themselves pay on average about 12% of the total value of the pension. So you could just, whatever number you think it's worth, or it's on the member statement, just multiply by 10 or whatever and be like, okay, it's probably somewhere in that neighborhood. I would say is just the sort of the quick version.
John, just so I'm clear on it, could you go back to the statement? Are you able to do that you just had? So you're saying that the two boxes, the one that's under the account summary and then the present value, you've put that in. What the statement actually comes with are the numbers up above and then the narrative on your future benefits, correct?
Correct, right. So where it says present value 1.1 million, that was something I added, to this PDF.
Yeah,
For
okay.
the presentation, right. But the 167,000, that number is on the statement. So I mean, and it even says on there, like right in the middle, it does say that the employer contributions are not reflected on the statement. So there's this whole huge pot of money that the employer, and CalPERS has put off to the side that you don't see.
Yes.
So it is misleading unless you read the fine print for sure. So it's,
Right. And the call centers,
out for.
unfortunately, the call centers don't do a great job, I think, at explaining all this to the parties, because I do get a lot of calls from the clients wondering why I came up with some crazy big number. And that's why.
So we can help you with evaluations if you're considering an offset for sure. So Quadra Council can do that.
As
So,
a heads up, it's 10 minutes to 1.
right. So we'll just keep going. Okay. All right.
Louise, do you want to take it from here?
Yeah, sure. Yeah. So also we have these defined contribution plans, which we talked about. They're usually held, they're held by outside vendors and you have to get a Quadra. So I'm just going to do a little segment on survivor benefits. And the law is, that you'll have it, and Kramer is the lead case that for a survivor continuance, which these plans could offer for a surviving spouse, that once the post-retirement dissolution occurs, the non-member no longer qualifies as a surviving spouse. There are some exceptions, but it's something to look out for. And so we're including just a brief blurb, even though it's not specifically on point for this talk, is for these county plans, these survivor benefits, survivor continuous can go away. And so you might want to consider a legal separation. You also can award a former spouse a portion of the survivor of any survivor benefit that could be payable to a current spouse. So if the member has remarried and they're retired, there may be a survivor benefit that with a domestic relations order properly done, you can secure survivor benefits to the extent possible. So how do you compensate for lost survivor benefits? These are the cases that could apply for you, especially for the county plan. So we're not going to focus on that, but I wanted you to have this information in case you want to pursue and try and get, especially if you're representing the out spouse, the ability for some sort of compensation. I would say the most common compensation is any type of life insurance that is available, even if it's, especially if the parties are elderly, it can't be based on health, but you can at least get a couple $100,000 possibly. These are the cases that deal with death for CalPERS plans, with public plans, Cooper, Sonnet, and Smith. And which one of these cases applies depends on the facts. Without too much of a deep dive into this, the Cooper case is the one that said you can do a complete offset of a CalPERS plan and the award in that case, the community interest, which I think this Cooper is very fact specific, that you can award 100% to the member as long as the member pays out the present day actuarial value of that plan to the non-member. And in a Cooper case, it was 100% survivor benefit on I think it was like a 4 or 5 year marriage, super short marriage. And so the court ordered that to occur. Sonnet was another case that dealt with how to allocate a survivor benefit that exceeded a community property interest. For instance, in that case, it was about 25% to the non-member, but in the event of death, it would bump up to 100%. And this decision that they ended up with is extremely impractical. because they said, well, you can create a trust, but nobody could manage that trust. Calpers is completely uninvolved. So I would say most people, just in terms of practice, follow the Smith in terms of the Smith holding, which basically have in a DRO have the reversion of a retired member. If the non-member dies, the reversion amount reverts back to the member. So that member has a possibility of 100% of the pension, and likewise, depending on the option selected at retirement, if the member dies before non-member, that non-member share could possibly go up to, for instance, if they chose 100% option, 100%. So if both people have the option of getting up to 100%, they just leave it alone and move forward, because they're really, I mean, I tell people this all the time. I don't know, John, if you do as well, but I'm sure we know it to be true. There's no perfect way to divide retirement benefits. So we just do the best we can because nobody is happy in the end with, well, I can't say nobody, but usually after much litigation, there are problems with enforcing the decision that came down on Sunday. Okay, I've talked too much on this, but it's fun. It's a deep dive, and there you go. Malpractice. We've done a lot of talks on malpractice. I just had to include this in because the judgment language regarding public plans is really important. Because the Quadro does facilitate what's written in the judgment. We do see missing plans a lot, et cetera. But what I'm going to zero in on right now is an award that's not possible. Like, for instance, I'll do a lump sum amount that, well, I would say the most common with PERS and STRs, especially because you have the option if the member's not married. If the member's not retired, is to just blanket your judgment language time roll. It may not be that time roll is the best option for the member or the non-member, and they want to switch to separate interest. But especially if you're representing the member may not want to be stuck with a time roll because the separate interest might be a better situation. I think it's best to keep the judgment language very general for the division of the retirement plans if the parties haven't yet decided which way they want to go, and not mention the time roll formula because that can mess things up. Judgment language should be plan specific if it's possible. We recommend, there's a California Judicial Council Form 348 that has good survivor benefit language, but it's always a good idea to mention survivor benefits when you're drafting the judgment language. And we have, for all plans, Quadro Council has automated plan specific and case specific judgment language that will help protect you in the event of any problems down the road with the domestic relation order not being done the way the parties anticipated due to the judgment language. So I always include this little blurb on defined contribution plans because those do come up with the public plans, is the award should be one of these four options. What happens in almost every case with judgment language is the award is 50% of the community interest. I mean, and a lot of times it says of the Fidelity 401k because it's a statement with Fidelity, or the Nationwide 401k, or whatever it is. If there is a premarital interest, there will be problems because, and those come up post-retirement, or post-judgment. We see this a lot with the parties because they feel like, okay, all we have to do, we got the judgment done. All we have to do is get the Quadro done. And then we tell them, well, this is an issue because the plan will not calculate the premarital separate property interest. So these issues have to be dealt with. And we've done a talk on this on just defined contribution plan issues, but I wanted to raise it here because the most important thing is if there's a separate property premarital interest. We do have a calculator that can help you with that, with estimates, with Quadro Council, or also doing a tracing if all the statements are available. But these are the issues. The point of this talk is to help you spot these issues. And these are the laws on gains or losses for a defined contribution plan. Not the focus of today's talk, to be clear, but because we are dealing with division of defined contribution plans, in a lot of cases, I would say most employees of state or teachers have two plans. They have a defined contribution plans, and a lot of times those are missed. Those are omitted assets. A lot of times the parties get the big, oh, it's CalPERS, CalPERS, CalPERS. They've got all that, but they missed the 457 or the 403B. And it's not, in many cases, anybody's fault. It's just the parties aren't really clear on what they have, what their assets are. So we
Louise,
just want to be really clear. Yeah.
excuse me, I just wanted to let you know, because this isn't an MCLE, we can run over and go through it all, and anybody who would like to stay on can certainly stay with us till we get through it. And I think
Okay, well, that's okay. We'll try and, yeah, if there are questions, I mean, we could also, you can contact us. We'll help you understand it deeper, but I really appreciate anybody who signed up, and we will be doing more MCLEs next year, but we're just trying to get the word out to as many people as possible about this, you know, all the issues that we deal with all the time and how we can help you. If the member is retired, that's the most important thing you need to know when you get a CalPERS or CalSTRs member, because then you can make decisions from there. If they're retired, you want to know, particularly so you know what you have to do to protect survivor benefits, if it's possible. Again, it's hard to get a post-death quadro. You can, it's a little easier with the state plans to do that, but if there are competing interests because the judgment language isn't clear or the quadro wasn't done, then the non-member could lose their right to the survivor benefits. But like John said, the jointers on these public plans do a great job at protecting the situation to the extent possible. But then the second thing they look at, if there's a death, is what does the judgment language say? So it's just easy to put in one sentence to protect and say, you know, including survivor benefits, make sure you mention survivor benefits, because California law, family law, so 2610 specifically has a provision that says that retirement benefits include all survivor and death benefits to the extent they're payable. So these are just the bottom line is to include a mention of survivor benefits. We have a really great system in place and tremendous support. So whether it's technical or a support on a substantive question, we're happy to help and steer people in the right direction and get them the information they need. In my dream world, because I've been doing this since 1994, and I was a plan attorney for half of my career, and then was a party attorney for the parties, is to draft your judgment and draft your quadros, get it all done at the same time. So when the members are they're motivated to sign because they're in a hurry to get divorced, they can sign it all at once. Then it's all filed concurrently, and once it's served on the plan, you know you can withdraw in peace, and you know your job's done, and that you've covered everything, you're protected, particularly that your client's protected. We are seeing judges now, which is great, that won't sign judgments until the quadros are done, because they don't want to have to open up the case again. They're backlogged. They don't want to have to deal with this, and especially if it's a contentious case, they don't want to have to deal with it. So that's why with our case management tool with Quadro Counsel, we help you manage your case from the moment you get it to figure out and know exactly what you need to do if there's a retirement plan that needs to be divided or offset in your particular case. Just closing thoughts. There's a million divorces a year in the United States. This is not a California only problem. This is a national problem. It's really I don't want to say a pandemic because we're all alive, but it's a huge problem because there are only about 40 pension division experts in the country. And that was the impetus in drafting Quadro Counsel or creating this platform, so that through technology, access to this information is available to the parties, to the divorce professionals, to the courts. And I just feel I'm very passionate about this. I know John is too. That's why we're doing this, that it's just time to change how we handle pension division. It shouldn't be an afterthought at the end and you just throw it in and say, okay, they'll deal with it later and I'm not involved. It's a good thing to stay involved. You don't have to be too involved if you don't want to. You can bring in experts, et cetera. But you're representing your client, and it's really a good thing to help your client all the way to the end. They'll like you better. They'll refer more cases to you, more other friends that are getting divorced too. But we just are really passionate about what we're doing and why we're doing it, and hopefully you have some idea of what to look out for with PERS and STRs in particular, because there's a lot of work that can be done beforehand, especially if you represent the out spouse, and figuring out which form of benefit you want to choose, and if the member's retired, what are the ramifications at retirement with survivor benefits. Those are, I would say, wrap it up in terms of the biggest issues. What do you think, John? Am I correct in that?
Yeah, definitely. Absolutely.
I know, just like throwing it all out there. I wish I could, I'm looking at the camera, I wish I could see all of you. It's really hard to talk to a screen, but.
Well, thank you both. We've had many people ask, and I know that Araceli has been responding. We will be posting at some point all of the webinars that we've done. And if you send us an email, we can get you the PDF copies of the slides that you've seen today or in previous. And we still have 2 more Zoominars this year, the last Friday of each month at 1 o'clock. So we hope you can join us for those. If you have any questions, you see on the screen right now the website, and we are offering that 30-day free trial, which has been very beneficial to a lot of new subscribers, where they've actually done their cases, unlimited access, use, and deliverables, and converted to subscribers. And we thank all of you very much for your participation and support. Well done, John and Louise, and thank you all for joining us. Happy Halloween, good health, and goodbye to everybody.
See you next time. Thank you.
Thank you.
Bye.
Bye.